African Union Summit was being held in Johannesburg, and some South African civil society organization took the matter to the South African High Court, and they were seeking an order to arrest a sitting head of state who is attending an African Union summit, whose instruments and treaties are very clear that wherever AU is sitting, all those invited by AU enjoy immunity. The events in South Africa has prompted to the discussion that we are going to have tomorrow. In order to deepen our understanding on the matter of the role of the International Criminal Court and its relationship with the regional intergovernmental organizations such as the African Union, and the relationship between continental laws and international laws, which laws that are continental are also international law. I hope you get me right there. Secondly, that we are going to discuss and understand, to try to put in perspective, the reasons why those that wanted something to happen, that something did not happen. And therefore, we're going to interrogate the very law that was used to undermine the legitimacy, the credibility of the African Union as an intergovernmental organization, which is also part of the international community, which has the biggest number of state parties to the Conference of State Parties to the ICC, and which is a pioneer of the Rome Statute. Without Africa, the Rome Statute would not have seen the end of light. And so all these issues are going to be discussed. But the context in which they will be discussed will be to look at, one, whether the international community was right to try and undermine continental laws and treaties and decisions, which are an extension of the very essence of international treaties and international law and practice. The second one is to see whether the South African government was right to be alleged to have done what they have done, they claim to have done, and whether the South African court was within the competence of law to act in the manner that they did. And therefore, we will put these three actors together, and at the same time bring in and project the aspect of the African Union. Some of you are aware the African Union has issued 4 decisions in relation to the ICC, and the chairperson of the Conference of State Parties of the ICC was in Nairobi 2 days ago, where I was also trying to share the perspective of the concern of Africa and African states in relation to this matter. Now, the question of the ICC, from the African perspective, we have not offloaded it. And I think the media has also not given justice to it. We are all swimming within the thinking of the international discourse without interrogating the 2 discourses of treaties and law in relation to Africa's position and also the provisions of the Rome Statute. Some of us are advocates for rule of law, and the rule of law says you must obey the law until it is amended, no matter how bad it is. That is when you say this is a democrat. So all our colleagues from the north who claim to be compliance of rule of law, the rule has to be obeyed, no matter how bad it is, until it is amended. And therefore, the Rome Statute within it has also certain provisions that, for example, the African Union used, that, for example, South Africa used, that, for example, America used with Senegal, that, for example, all other states have used. And so when you evoke certain provision, you are within the law. And when you are within the law, the competence of your being is protected by the law. But we have seen a complete shift from north to south, to center, to central, to every time. And as Africa, I think we are concerned because we are raping international justice. And our view is to ensure that the international community, especially our colleagues in the north, immediately stop raping international justice system, so that justice is complied to with justice, not judicial justice being replaced by political justice to gain political advantage. So these are, I think, issues that are very important that we are all going to discuss tomorrow. And within there, we will also be projecting the question of sanctions. In particular, unilateral cohesive sanction, which the UN Human Rights Council in various interpretations has said, and I quote, unilateral cohesive sanctions are illegal in international human rights law because the international legal system, as espoused by the UN Charter, provides sanctions must be approved by the UN Security Council. Any sanctions that are imposed without clearance or support of the Security Council is considered a rape on the international justice system. So we hope to be with you tomorrow so that we could begin to dissect, and I think we have a responsibility now to dissect the misunderstandings or deliberate interpretation of the international justice system in order to give hope to every citizen on the continent that unless you are proved guilty, you are innocent until proved guilty otherwise. So it will be an opportunity that the media in Ethiopia must begin to interrogate the African Union on its decision. What does that mean? Must begin to interrogate and question whether the decision of South Africa in relation to the June summit was correct, and those one who did what they did. If you quote the interpretation of the judge, which I don't want to quote now, but I'll quote what he said, and he himself said he was wrong, but he issued a judgment. Even if he was issuing it, he didn't know what he was doing, you know, in his own weight. So it is an opportunity that we have to begin to engage. The ICC may go into extinction. The ones who established ICC is Africa, and we have an obligation to save ICC from collapse in order to ensure that there is international justice. Africa has been misrepresented, misinterpreted, that we are protecting or promoting impunity. Not at all. Unless one inculcates their knowledge inside the African values. The African values are very clear. And in those values are founded our principles of law and our action.